Welcome to The Geek in Review, the podcast focused on innovative and creative ideas in the legal industry. I'm Marlene Gabauer.
And I'm Greg Lambert. Well, Marlene, you look a little healthier than you've looked the last couple of weeks, so it's good to have you back on.
I was not doing too well last week. I caught the dreaded COVID, but first time. But thankfully, it only was about a week. And
see, you probably thought you were special, right?
I thought I was the cure. I thought I was the cure. I'm not, apparently.
Well, we have a great episode today. We have a friend of ours, Damien Riehl from Fast Case, and Sally is on with us. So, Marlene, I think I took your line, didn't I?
You totally took my line. But I would like to welcome you, Damien. Damien is the Vice President of Litigation Workflow and Analytics Content and part of the leadership at Sally. Damien, we're very excited to talk about Sally. We are longtime fans, but we're also going to talk about legal tech, music, and more.
Yeah, definitely more.
It's going to be a great podcast when you say "and more."
I'm so thrilled to be here. Thank you so much for having me.
Yeah, this is one of those where we have a general outline, and we're just going to see how the conversation goes. So, Damien, wanted to start off first with talking about Sally. We've talked about Sally standards before, but you're kind of I think you're one of the biggest motivated people behind it and getting it out there and getting a lot more content in on the back end with Sally. So would you just kind of give us an overview of what Sally is and some of the things that you've been working on lately?
Sure. Marley, did you want to say something?
I was going to echo that, just like, what's the basic concept behind Sally? I think a lot of people might not kind of fully understand sort of, what's the purpose?
I love that clarifying question. And so think of Sally as a bunch of tags. So much like you go to Amazon and you see the left-hand view to be able to say, okay, I've run a search for, sports jerseys, right? So now I've run a search, and now in the filter, I want to say in the filter on the left-hand side, there's tags for men's sports jerseys. There's tags for women's sports jerseys. There's tags for children's sports. Like each of those is something that Amazon used to tag up their products so you as a user are better able to filter and analyze those things. So think of Sally almost like that, where Sally is a bunch of tags, but instead of sports jerseys and men's clothing, women's clothing, you can instead say, give me this area of law, patent law, and then give me this service. Am I giving advice for patent law? Or am I instead, should I get a patent? Is it advice? If I decide, yes, I'm going to get a patent, then I file it with the Patent and Trademark Office. That's the registration service. And then I maybe license the patent. That's the transactional service. That's a different tag. And then I litigate the patent. That's a dispute tag. And then I deal with patent assets in bankruptcy. That's the bankruptcy service tag. So you can imagine if I tag up all of my matters, then I'm able to say, okay, show me all the patent things that I've done, whether it's advice or litigation, etc. And then I can find the like with like. Show me other times that we've done this matter. Similarly, we're also, for what industries are we doing this work? Is my clients maybe an information industry, that is the counterparties in the agriculture industry? You could tag up with the agriculture industry in that. And then you could be able to say, okay, what kind of documents have we done? Have we done merger agreements, motions to dismiss? Okay, that's another type of Sally tag. Wouldn't it be great to be able to catch all those? And then you could say within the document, is there a force majeure clause? We're tagging that up. Is this a breach of contract motion? Is this a negligence motion? Is this a trade secret motion? We're tagging those things up. So we now have version 2 that came out in 2022, had 10,000 matters. It's 10,000 tags of everything that matters to the substance of law and to the also the business of law. We have jumped now from 10,000. The newest version that we're building has about 13,000 tags. So we just keep marching through to be able to essentially take everything that matters to the substance of law and to the business of law, providing tags that then, once you've tagged them up, really the value proposition is Sally's now being adopted by Thomson Reuters. And Sally's being adopted by Lexis. I just had a meeting with Lexis today. Sally's being adopted by Bloomberg. Sally's being adopted by NetDocuments in a big way. Sally's being adopted by iManage. So you can imagine each of those 13,000 things being standardized within each of those products. So an example, and of course I should say my employer,
Dr. Fastcase. This gives you a good chance to say that Fastcase is also doing it, right?
It's true, yeah. So for example, today we've tagged up all of our 225 Sally motion types: motion to dismiss, motion for summary judgment, motion for 225 of those. we've tagged each of those motions up with the Sally identifier for a motion to dismiss. So if you send me at Docket Alarm the Sally tag, give me all the motions to dismiss in the Southern District of New York for breach of contract, we would be able to give you all of those back. Send that same API query to Thomson Reuters eventually, and they'll give you all of that back. Send that same API call to Lexis, and they'll give it back. So this way, everyone is using the same identifiers for the same legal work.
So when you're talking about Thomson and Lexis, when we're talking about integration, I'm assuming into their products, are we talking about their information products? Are we talking more about their financial products?
So Thomson Reuters has said publicly, so I'm saying not only what Thomson Reuters has also said publicly, but Thomson Reuters has said publicly that they are integrating Sally for every single one of their products across,
so
and they're just marching through.
Okay.
I can't talk about the roadmap of the thing that they're building. I
know.
You know the products. I can't say them.
Yeah.
But what I can tell you is that Legal Tracker is the first one that they've done. And so really the process for that is that Thomson Reuters and Jim Hannigan from Sally and I said, okay, let's say Legal Tracker had 500 different fields and tags that they wanted to be able to map up. So we just did one by one. We mapped all of them. About 95% of what Legal Tracker had, Sally already had. And for that 5% that Sally did not yet have, we pushed those into Sally. So now Sally has 100% of Legal Tracker. Also, importantly, Sally had a lot of things that Legal Tracker didn't yet have, and now Legal Tracker pulled in some Sally things that they didn't have before. So that's the kind of bi-directional improvements that we do with Thomson Reuters. Similarly, with NetDocuments is another one where they have said publicly at their NetDocuments conference in Denver, which I was able to be a part of. They have said that step one for them is I, as a user, could be able to tag up my motion to dismiss, breach of contract, negligence, or my merger agreement that has a force majeure clause. I could do that manually as step one, but soon after that, this year, they plan to say, hey, your document is a motion to dismiss for breach of contract and also has a negligence claim in there. Do you want me to tag those things up programmatically? And the user could say, yes, please. So this is a way to be able to essentially tag up all of your documents, tag up all of your matters, tag up your everything, because once then you tag them up, you can analyze them. How much does a motion to dismiss in the Southern District of New York for breach of contract cost? Once you have those tags, you're able to do that work.
And what's interesting is, like, because it's across the board in different organizations, and that one of the early arguments in favor of Sally was that, okay, this was across the board. Okay, everybody was using the same standard, and so you could compare apples to apples. And this, it sounds like there's a real opportunity to get this into firms in order to really make that happen.
That's exactly right. And even so, within firms, the problem that we're solving for vendors like Thomson Reuters, the person we're working with, his name is Corey. Corey's boss said, hey, Corey, we have 30 products that don't talk very well to each other. You need to make them talk to each other. Corey said, gosh, I'm an engineer. I'm not a lawyer. Building a taxonomy for the law is really hard. And then he said, oh, wait, Sally's already built it, and it's actually really good. So what he's using is Sally is to be able to have all 30 of his products talk to each other. And the side benefit of that is then the API calls that, he can open that up to law firms. So then say if you want to hit any of those 30 products, then you're able to use the Sally API query and then be able to hit any of them. And of course, Docket Alarm, the same idea. If you hit us with an API call that is Sally, we're able to do that. So Thomson Reuters is using it as a universal translator, both amongst their internal products as well as external products. And then, of course, as a law firms, we're also solving a problem for vendors like us that each individual law firm might have their own bespoke taxonomy that has their crazy, areas of law that nobody's ever heard of before. So I, as a vendor, it's a lot of work for me to connect with 1,000 of my mappings to theirs. Wouldn't it be better if I, as a vendor, say, hey, law firm, use Sally, and then you're out of the box, you're compatible with us. So that's really the grand idea.
I can almost guarantee if a law firm has a taxonomy, it's a bespoke taxonomy.
Yeah, well, it depends. Sometimes it's client by client, but if you can basically sync those using your existing products, that makes it a lot easier.
That's right. And so one of the work, Intap is doing a lot of really important work with this, and what they're doing is they're trying to solve the problem that I just described. They're working with hundreds or thousands of law firms that each have their bespoke taxonomy. So they've built a really cool parser to be able to see what a law firm calls an area of law. So, for example, they went through some of the largest law firms in the country, and they scraped from their website all of the areas of law that they have in marketing. One of those areas of law is appeals to the PTAB, okay? And they call that an area of law. But then the system that they built is to be able to extract that is not an area of law. The area of law is patent law because it's the Patent Trial and Appeal Board. So that's the area of law is patent law. The service that is being provided is the appellate litigation service. So that's the appellate is the service, that's tag number 2. And tag number 3 is that the PTAB is actually a forum. It is not an area of law. The PTAB is a forum. So what this INTAP tool is doing, and we're building it internally at this point, at some point we're going to release it to the world, is you can input maybe 100 or 1,000 rows of what you call a thing, your bespoke taxonomy, appeals to the PTAB, and then it will translate that to the SALI tags. Because you can imagine appeals to the PTAB as a single tag isn't nearly as useful as the 3 tags of show me all the patent law things that we've done. Okay, now show me all the appellate things that we've done. Okay, now show me all the PTAB things that we've done. Each of those as a individual is much more valuable than the lumped Frankenstein that is appeals to the PTAB. So anyway, so that's all a way of saying that even if the Frankenstein monster that is your law firm taxonomy, even if on the front end the lawyer still says, nope, I want to see appeals to the PTAB as a thing. Cool. Give them a button that says appeals to the PTAB, but then on the back end, tag it up with patent law plus appeals plus PTAB. So that it's the best of both worlds.
Yeah, I think one of the things that when you talk, Sally, especially to someone that just hears, standards, oh, great, here's one more layer of work that we're going to have to do. And we've learned from our iManage or our document management systems that when you kind of make the person, the attorney or the secretary or assistant, tag that, it tends to either go in general or we laugh. It's like if it's tagged to a country, Afghanistan tends to get a lot because it's first on the list. So, and we're going to talk a little bit more later about some of the AI tools that are hitting the market. And I know you've hit some of this with the way that some of the third parties are going to kind of automate the system. Is that how people like us should approach the powers that be at our firm when we talk about standards? Because I think to them, they just see it as, oh, God, we're going to have to hire a boatload of people to come in and look at everything and tag it, and we'll just do without it. So is automation and are there other things that are going to be the way that these types of standards get implemented at the local level?
Oh, 100%. Yeah. So I would say that if humans are doing most of this, then the organization is doing it wrong. That is, a lot of this is automatable in the ways that I described earlier, to say you could input 1,000 rows and output the SALI tags that go to that 1,000 rows. That's example number 1. Example number 2 is actually within Docket Alarm. We have a pleading tag where we look at a docket and it says order granting motion for summary judgment. We recognize order as a SALI tag. We recognize granting as a thing that happens, a disposition, and then we recognize summary judgment as a pleading within the SALI side. So each of those things, we use 0 humans for that. We just programmatically extracted that order is a thing, granting is a thing, and summary judgment is a thing. So it's 100% machines, and it's just a matter of vendors like Docket Alarm, vendors like NetDocuments, vendors like INTAP, essentially building the tools to make the firm's lives easier. Because we, on the vendor side, can build at scale. So, for example, we at Docket Alarm have built that extraction, order granting, summary judgment. The precision of that, you think about accuracy, precision. Our precision is 99.6% precise. We think humans are about 96 or so, maybe 97% precise. So our machine is better in accuracy at extracting these things than humans are. So all that's to say that how many ways are there to express the word summary judgment? I would argue 1, summary judgment, right? Do you have to have some fancy GPT or any other large language model to be able to extract the word summary judgment from your document, from anything? Right. And the answer is no. Summary judgment is summary judgment. Negligence is negligence. So really, of the SALI tags, almost all of them are verbatim. Sometimes there's things like motions to dismiss, which in California are called demurrers, right? So within SALI, we have motion to dismiss as a tag, and we have a synonym of motion to dismiss is demurrer. So the system can pull these things in. So all that's to say that if humans are tagging these things up, you're probably doing it wrong. Rely on a vendor and encourage your vendors to use SALI and to be able to pull the SALI tags out. And even if you don't use a vendor to do this, there are easy ways for the machines to be able to extract things. at a high precision and high recall.
How granular can the Sally tags be? In other words, I assume time entry, I assume documents. What other kind of day-to-day tasks or information that lawyers deal with can Sally help organize?
A great example of this is the UTBMS, also known as the ABA task codes. That is the bane of every litigator's existence, including me. I was a litigator for 15 years. And so when I was entering, I took a deposition, so I put in my time entry, deposition. Ostensibly, that's to figure out how much a deposition cost. But I, as a litigator, know, well, am I taking the deposition or am I defending the deposition? Because that's going to be, or am I merely observing the deposition? Those are 3 different cost points. And then is it a fact witness, or is it an expert witness? Or is it a 30B6 corporate witness? Each of those is going to move the needle as to more expensive or less expensive. And then is it a patent litigation, or is it a slip and fall? Because that's going to move the needle. And then is it in New York, or is it in Podunk Nowheresville? All of those things will really tell you things that the ABA task code, that is deposition, will not tell you. Each of those tags that I've just described is a Sally tag. We say, are you taking the deposition? Are you defending the deposition? Are you merely observing the deposition? Is it a fact witness? Is it an expert witness? Is it a 30B6 corporate witness? And so you can imagine on a time entry, you could say, took deposition of expert so-and-so. Took deposition expert. Cool. I'm going to tag up those 3 things. That is very granular. And now, if I know that this is a patent matter that's venued in the Southern District of New York, all of a sudden I have much more granular data points that I didn't have with the ABA task code that just said deposition.
So I was curious, how are firms and maybe, counsel, in-house counsel sort of using the Sally codes? I mean, pricing, staffing, maybe business development. What are some ways that you're seeing, creative ways that you're seeing them being used?
A good example of Jason Barnwell from Microsoft. Jason is smart in many ways, as your listeners know. He's solving a particular business problem where 2 of his business units are being regulated by various regulators, say the FTC or the FCC. We have tags for FTC, for FCC, etc. So his business units are tracking regulators, and then the second column of things that they're tracking is the regulations, the Federal Trade Act, etc. And so he's using Sally to be able to tag up all of the regulators and the regulations and be able to tag them up using Sally. And then he's going to be requiring all of his law firms that work with them on those regulatory matters to also tag up their matters using the FTC Sally tag, the FCC Sally tag, etc. So that way, as they bidirectionally communicate, they're able to use Sally as a translator between the firm system and the Microsoft system. So that's just one example of how this is helping a client, Microsoft, communicate with their law firms. And then you can imagine if some of the documents that they're creating is in net documents or in iManage, then iManage is essentially tagging up FTC and FCC in the same way. And so this is kind of the tri-directional, client plus law firm plus vendor, where everyone is using the same tag for FCC. Therefore, you could be able to push and pull data to and from each other.
Has it impacted at all, like time entry, like how people, I mean, not necessarily the tags, but like how people are actually writing their time?
It's a good question. And when I worked for Thomson Reuters, I can't talk much about the work that I did for them, but I can say you can imagine that there's 2 ways to be able to create time entries. That is, I, as a lawyer, type time entry. That's way number 1. Way number 2 is that the system writes the time entry for you. It knows what you're doing. It sees that iManage is a motion to dismiss for breach of contract in the Southern District of New York, and that could maybe populate a time entry, right? So really, what is a time entry but Sally tags embodied in a narrative text, right? So one could imagine that are we going to have narrative time entries where a human is actually writing things? Or are we going to have extracting the tags from iManage or extracting the tags from the work that you do? And is the tag the thing that you care about less than the narrative side? So anyway, so all that's to say, that am I changing the way that I write my text to be able to help Sally? Maybe. Or maybe the systems you're creating in the future, maybe near future, will essentially export the Sally tags of the things you're working on.
Well, I know many people, if they didn't have to actually do their time entry and it would just be kind of done for them, would be super happy.
It's true.
It's true. They'll never be totally happy, though.
That's true. As long as the billable hour reigns supreme, I guess happiness will elude us.
So, Damien, we wanted to shift to sort of the AI portion of the conversation now, if you don't mind. And We had Tony Tai and Ashley Carlisle from Hyperdraft on a couple of weeks ago, and we were talking again about, and this was sort of right when it kind of broke, and we didn't have quite as many examples where suddenly it's like, oh, it's only information from 2021, and it cuts off, and we're finding all of these mistakes and things like that. So, they were also kind of cautioning about some of this generative AI, and I'm wondering sort of what your take is on, some of these, shiny new tools that are entering sort of this day-to-day discussion.
I think that the GPT in particular and large language models in general, like BERT on the Google side, BERT is also using Lambda. So I'm going to use large language models, or LLMs, as a shorthand for GPT-like things. So I would say large language models are really transformative in a way that I, as a skeptic of this is going to transform the industry, I hate when people say that. But now I find myself saying that on this particular podcast, because I distinctly remember in late November, early December, sitting at my kitchen table, and my wife will attest that I said lots of expletives and said, this is going to change everything. And I've now tempered down my enthusiasm for this. Not going to change everything, but it will change a lot of things. And so some of the ways that I think it will help is large language models. Yes, they are generative AI. That is. I want to create a text. Write me a poem. Write me a short story. The problem is they're also hallucinatory, as has been probably demonstrated lots. That sometimes they speak the truth, sometimes they don't speak the truth. There's a know-it-all, sometimes right, sometimes wrong, but always certain, right? So the GPT is really, sometimes right, sometimes wrong, but always certain. So anyway, so that's the generative AI side of it. But there's also a generative extractive AI. So as a Gen Xer, I call that a Gen X. And so what that is, for example, here's a paragraph of text. Summarize that paragraph of text. So that's generative extractive. Here is a bunch of arguments. Here are a bunch of arguments. Create counter arguments from those arguments. So that's extracting the arguments and generating counter arguments. Create a decision tree as to whether I should do this thing or that thing. Then it generates a decision tree. Classify, given this text, here's 3 paragraphs, or here's 100 pages. Classify all the causes of action in that text, maybe with Sally tags, and then it outputs that classification. Create bullet points that is summarizing the most important aspects of this 4 paragraphs that I give you right now. So anyway, all of these things are not generative AI. They're not write me a poem. They're not give me a brief, right? But they're saying, given these 3 paragraphs or these 5 pages, extract stuff that matters, and then generate useful things that comes out of it. So I think that the most transformative aspect of it is not the generative side, but what I'm now calling the Gen X side of it, the generative extractive side. More extractive generative, I guess, is the X-Gen, but it's not nearly as far as saying Gen X. But I would say that the generative extractive is the most promising because it's really, even today, it's really, really good at that. And so that's, for example, what we're doing right now at Doc Alarm. Just yesterday, we released something that said, if I, as a user, hover over a Doc Alarm document, and maybe I want to click on it, maybe I don't want to click on it, I could now go to my GPT summary. And what it does is I click that button, and it runs that through GPT and gives you the 3 bullet points as to what that document is about. So now I don't have to read this 50-page document if I don't want to, or this 10-page document even. Now I can read 3 bullet points to see if I actually want to read this document. So this is an example of this generative extractive concept, where it's extracting the document, giving a really good summary, and that is in a useful way. No one is going to accuse that of robot lawyering, and it's not nearly as sexy as saying, I'm going to represent you in court, but it's really useful, and it's really accurate. And so that's I think that what is transformative is the more even-tempered, given this text, give me the stuff that matters out of it.
Now, I know you did a test and I think you posted it on Twitter, and wrote a quick article about it this week, and where you did that, where you gave it certain issues, and then you fed it in more information, and then said, all right, now that we have this, come back with X, and it was just a process that you did. I'm curious, did you have any naysayers attack you on Twitter yesterday when you posted it?
I would say no, largely because I would like to think it's because my logic is unassailable, but that's probably not true. But I would say that really, if we think about humans are really good summarizers. We have really good AI between our ears, right? And so the example that I gave in the LinkedIn is essentially using the AI of humans. That is, I as a human want to summarize this 50-page document, and so I summarize it in a way that's human readable. That is called a table of contents. And so the use case that I used, that I showed in LinkedIn, is I gave GPT a table of contents appropriately for the OpenAI lawsuit that's going on right now. OpenAI is being sued by a bunch of coders, and they're being sued over GitHub Copilot, which ingested the entirety of GitHub, figured out how code works, and now I, as a coder using GitHub, can be able to essentially output code by saying, hey, write me a website code that extracts, that scrapes content from this website, and it'll generate that code programmatically. The way that it can do that is because it's already ingested the entirety of GitHub to figure out how code works. So GitHub is being sued right now, saying that the coders said, hey, we released this as a license. You breached that license. Therefore, now you're not supposed to be able to ingest the GitHub. So that's what the lawsuit is. So I used that lawsuit table of contents for the motion to dismiss from OpenAI, where I ingested the arguments from the table of contents, and I said, okay, ChatGPT, create counter arguments based on the arguments, and take these arguments in the table of contents and create counter arguments from those table of contents. And then it created counter arguments to be able to say, and it gave me really good ones. So the irony is that I was using OpenAI's GPT to argue against OpenAI's litigation of GPT and essentially using the tech that they're being sued over. So there's a fun irony there. Then on top of that, so that's really cool that you created the arguments that are condensed. And, the cool AI is that that brief writer wrote 50 pages worth of content and then said, wow, 50 pages is hard to grok. I'm going to summarize that in the table of contents, right? And so essentially we're using the human AI, which is now I'm going to condense 50 pages into a page. And now we're taking a robot and saying, okay, now take this human condensed table of contents and write counter arguments based on that human condensation. So then the counter arguments turned out to be really good. And then I took it a step farther and said, okay, for each of those counter arguments, provide facts that could be used to demonstrate each of those counter arguments. And OpenAI gave really good facts that I, as a lawyer, could, if this gets past summary judgment, use in my depositions, use in my document requests, use in my any type of legal proceeding to be able to essentially brainstorm. This is not robot lawyering, but it is a useful thing that how long would it take a first-year associate to write counter-arguments to a motion to dismiss? How long would it take a first-year associate to be able to figure out facts to be able to extract, to be able to point to show how those counter-arguments are wrong? A while, right? But it took me less than a minute to do this.
When you say facts, you're talking about a factual scenario, not necessarily that it's going out and giving you facts of this particular situation, right?
That's exactly right.
Because I think that's where it tends to fall down, is when you ask it to give you specifics.
That's right. Give me factual scenarios, I think is the what I had asked it for. So not things that have happened, but things that could happen. And of course, that's those are things that I ask my clients. Hey, has this thing happened? Okay, number 2, has that thing happened? Okay, number 3, has this thing happened? So this is ways that I can explore with my clients to brainstorm with them as to scenarios. And all of those are really good on the output side.
So my eldest son and I had a discussion about this the other day, and right after this all broke, maybe a week later, there was a student that basically came out and said, okay, if you write a paper using ChatGPT, like this thing that I built can tell you whether or not you did it or not. And of course, my son was very upset about this because it's like, why is he ruining it for everybody? And he's in college. I don't understand. And I said, well, that's one way of looking at it. I said, but you have to learn how to write. You have to learn how to craft an argument. You have to understand how concepts go together and how to sort of move from idea to idea before you can sort of use these shortcuts. And I want to go back to sort of what you were saying about how, it would take a lot longer for an associate to do this work, but what are we doing by essentially cutting out that opportunity for them to learn in that way?
that is really the question that I've been talking about with my wife, who is a professor of English. So she's been teaching composition for now 25 years. And so she input a bunch of the queries to say, write a comparison of the bluest eye and the color purple. Take two characters in their experience and talk about their experiences with race and how they both are similar and dissimilar. We wrote that prompt into ChatGPT, and the output was like A- work, and that's with 0 work, right? So then, so she kind of had this existential question, like, what am I doing? Like, what have I been doing if a machine can essentially output pretty good stuff? And so I think of it a lot like, we teach people how to be able to multiply and subtract and add, right? Those are things calculators can do. So there is the idea that knowing what is behind the calculator is important because you want to know the concepts. But mostly you're teaching them by doing that how to think, how to think in ideas. Once you get to a certain point, you give people calculators and say, okay, now that we have that foundation, let's jump faster, stronger, better. So applied then to English and to ideas and lawyering, we now have this tool that gives us a really good head start. And so our jobs now as humans, maybe we can use that as a way to leapfrog, much like a calculator is leapfrogging. And now I can use my critical thinking skills, number one, to be able to say, is what I'm seeing accurate? That is, I'm not going to accept at face value what it comes in. I'm going to use critical thinking skills to be able to assess whether it's accurate or not. That's thing number one. Thing number two, what is it missing? What are the things that are not showing up here? And then number three, how can I add to those things? So using it like a calculator to be able to say, all right, now I'm going to use this as a first step that now I can go faster, better, stronger. So an example from the LinkedIn post that Greg mentioned, for this factual claim, OpenAI's actions were the direct cause of plaintiff's injuries. I said, now provide factual examples of how a large language model training on text would cause an author of that training text to lose money. That was my prompt. It gave 4 examples. I'll only go through one of those with you. The example that it output said that OpenAI used an author's copyrighted work as training data for its large language model without obtaining permission from the author. As a result, the author lost potential revenue from licensing their work to other companies for similar uses. That's a really, really good answer. That is essentially hurting OpenAI's case, right? So now I, as a brief writer, could be able to say, yeah, what OpenAI said, right? I can essentially mimic that, or maybe I could say, it gave 4 examples. I can use that as a jumping off point to say, oh, now that made me think of example 5 and example 6, right? It's getting me to maybe the same place I would have ended up, maybe farther, but we won't tell anybody. But really the idea is that this is a way to be able to spur thinking and to create new ideas where maybe writer's block or a blank page might have kept us from keep making those new ideas without it.
Damien, that really kind of gives me almost two things I want to think about on this, and that is, never underestimate the Bar Association coming in and shutting this down, and then 2, you mentioned earlier about issues of copyright and things like that. So let me jump into the copyright part of it. And I know that this is an area of expertise for you as well. So, let's talk about that. You yourself are known for challenging the rules for copyright, and in fact, you have a TED Talk where you talk about generating, some billions of musical connotations that put on a disk and they're onto a hard drive, and thus have copyrighted that by doing so. What are agencies like the U.S. Copyright Office, what kind of rules are they going to establish? Are they going to be able to kind of look into the black box of all of these large language models and determine, are you taking copyrighted material and using that without getting a license? What's going to be some of the issues that we're going to see, and I think we're going to see relatively quickly?
So 2 aspects, actually a bunch of aspects from what you just asked. I'll take each one in turn. Right. So there's the generative aspect of it. That is, if machine created, is it copyrightable? So this has currently been before the Thaler case, where a Thaler had AI generated art, tried to file it with the Copyright Office saying, I'm not the author, the robot is the author. Therefore, grant me registration. The Copyright Office says no. Machines cannot receive copyright because IP is a constitutional concept saying for limited times to advance the progress of the useful arts and sciences, you shall have limited times of monopoly, essentially, is what they're saying. So that is incentive for humans to make new things. Machines don't need incentives. Machines, for the example of my All the Music project, I hit a button and it spit out at a rate of 300,000 melodies per second. We're now up to about 417 billion melodies that are written to disk. Under the Berne Convention, once written to disk, they are copyrighted automatically. So the question is, now that I have 417 billion melodies written to disk, which ostensibly includes every melody that's ever been and every melody that ever can be, mathematically, I've exhausted the entire data set. Is that now copyrightable? To be able to keep this from being used nefariously, what I did then was put everything in the public domain under Creative Commons 0. And the idea is to be able to say, argument number one, maybe each of these melodies that the computer cranked out at 300,000 melodies per second, maybe that's not copyrightable. And so that may be unoriginal, therefore uncopyrightable. That's the primary argument. So the same way, maybe the output of GPT is similarly uncopyrightable because machines do not need incentives to be able to create things. And really, if you think about what copyright is, really copyright is the right to exclude somebody else from doing a thing. So really, if I were to copyright my 417 billion melodies, I could say, now nobody else can use those. I get life of the author plus 70 years. Or in the case of an institutional author, 120 years. So now those are locked up for 120 years. Or GPT's creation is locked up for 120 years. That's just crazy talk, right? So anyway, that's all a way of saying that I think on the output side, is the output of LLMs and is the output of a machine, is that copyrightable? I think the only sane way to come out is no, because otherwise humans won't be able to build anything because the robots will cover the entire waterfront. So that's on the output side. Now on the input side, if GPT ingests the entirety of the web, or GPT ingests the entirety of Wikipedia, which it has, each of those things is copyrightable. If you make a website, that is copyrighted, right? Books from Google Scholar are copyrighted. So anyway, so the argument that the OpenAI case that the coders were making are, hey, I made code, my code is copyrightable, you ingested that code, therefore you're violating my copyright. But that's actually not what they're arguing in the OpenAI case. They're not arguing copyright infringement because there's a bad case for them. And that bad case is the Authors Guild. The Author Guild in the Second Circuit concerned Google Books, where Google Books essentially scanned every book in existence. And the Authors Guild sued them, saying, hey, these are copyrighted, you can't do it. And the court said, yeah, it was a copy, technically, but it's fair use, because the use of that book was transformative, because what Google was doing was creating an index of every book ever written, and then feeding back, I as a user could run a query and then get a snippet of that book and doing it back. And the Google Books court said, yes, even though you ingested every book, that snippet you provided is a transformative use, therefore fair use, therefore non-infringing. So if creating, and in Google Books' case, they sometimes provide 3 or 4 pages of full text of the book. If that is fair use, then how about the GitHub, where they're not reproducing 3 or 4 pages? If you know how large language models work, they're extracting the idea of a website. They're extracting the idea of scraping. They're extracting the code for each of those ideas, and then they're combining it in vector space and outputting a brand new thing that hasn't been done before, but is merely taking the information in the world and transforming it into a new generative thing. So if Google Books is transformative, this other thing is certainly transformative. So that's why they're not hanging their hat on copyright infringement, but instead what they're saying is, oh, we have a license, that of the MIT license or whatever license that they use for GitHub, and they're saying you breached the license to do that. So they're trying to essentially, they want to have a copyright-like protection, but they're using a license to be able to try to enforce that copyright-like protection because Google Books is a bad case for them. But then, of course, the response to that is, okay, if I have a book and you have a seal on the book and saying by breaking the seal on the book, you contractually agree that you will not be a Google book to scan my thing. Of course, you can't have a license to keep you from doing something you're otherwise legally able to do. That's just ridiculous. So essentially, that's why I think that the OpenAI case is probably going to lose, or at least should lose, if the court is doing it right, because all the machine is doing is what humans do all the time. I read a bunch of books. I assimilate those ideas from the books into a new expression of those ideas in my works. So that's all the machine is doing in the large language models. They're ingesting copyrighted things, figuring out the ideas and how language works, and then creating new things just like humans would.
We're talking a lot about lawsuits and a lot of discussion as to, what is right and what is wrong. So, of course, we're going to be talking about regulation because, that's not far down the road. Any ideas on, how regulatory agencies are going to try and limit or expand or control these tools?
So I would say for a tool is a tool. So a hammer is a hammer. I can use it to build houses. I can also use it to hit somebody over the head with, right? One tool is useful, another is criminal, right? So really, GPT, large language models like BERT, these are tools. So how do you use them is the real question. So is a hammer illegal? Well, it depends on how you use it, right? Is GPT the unauthorized practice of law? Depends on how you use it, right? So I would say that if you're a regulatory agency, think about another profession that was threatened by technology. So think back to the early 1980s. Think about CPAs, what they did for a living. What CPAs did was have ledgers and books, and they added numbers together, and they figured out, what a profit and loss statement would be. All of a sudden, a thing came by that's called a spreadsheet. All of a sudden, all of these accountants are thinking, gosh, where's our jobs going to go, right? That's all we do all day is just add numbers together, and all of a sudden, in a millisecond, this thing comes out. Imagine if the regulatory agency creating for accountants had said, hey, we need to kill this thing in the infancy because otherwise we won't have any more jobs, right? Hey, let's figure out how it's going to work. Maybe we'd have
something better than Excel if they did that.
Maybe, but what the accountants found out.
What?
That's right, Lotus 1, 2, 3. Exactly. I'm old enough to remember that too. But really what happened is the opposite happened because the accountants realized that once the clients figured out that it wasn't going to take a week to get their numbers back, but it would take a day to get their numbers back, they'd say, hey, accountant, how about you run these numbers with this scenario? Cool. How about this scenario? How about this scenario? How can I do tax to this? And they realize it's actually more work. And we have way more accountants today than we ever have, largely because of the spreadsheet. So if you're a regulatory agent, is GPT going to eat jobs, or is it going to make us more efficient and better to be able to create more work, to be able to feed the access to justice gap that is really everyone is talking about? No one can afford lawyers because it's too expensive, because we're too slow and we're too expensive. Can GPT make us faster, better, stronger to be able to provide self-help or to provide, limited services using lawyers, smart lawyers, using GPT as an exoskeleton?
Like Iron Man.
Like Iron Man, exactly, as an exoskeleton to make you faster, better, stronger. And so really that's, I would say that any regulatory agent thinking about banning such things, think of it like a hammer or like an Excel spreadsheet. It's a tool, and it might actually give our society more and better things than we have today.
All right, I'm gonna follow up on that and be a Debbie Downer, I guess.
Hey, Debbie Downer, because he just was talking about how the way it's like you flip the way you look at it.
Yeah. Well, yes, we have more accountants than ever, but just like with the expectation that a tool like this will help those at the bottom who need the help, I don't think that happened in the accounting industry. I think what happened was that gave them more opportunity to take bigger, much more of the pie for their existing clients and potential, larger clients. And so, and this is not necessarily a question, but kind of a statement. I would say that, in the perfect world, that a tool like this would enable access to justice issues. In a world like perfect world, allowing non-lawyer owned law firms in Arizona would mean that people would come in to service the people who need help getting access to justice. And what it's done is it's actually brought in high-end work into the state instead of the middle and low end of the legal pay scale. I kind of worry that if we're looking at this as a access to justice issue, I would say history is not in our favor of this being an access to justice way to fill that gap. Maybe I'm wrong. Hopefully I'm wrong.
As an analogy, though. So let's think through our accounting example. Of course, accountants often do taxes. So think about, the 1990s roll around, and there's a thing called TurboTax. that now I've not used an accountant in my entire professional career. I've used TurboTax, so I spend $150 and then get it out the door. That is access to justice, right, for accounting. That is self-help that I don't have to hire an accountant anymore. So now through the tools, I'm able to do an unserved market, I guess, So you can imagine on the legal side, a similar thing happening. And maybe we have self-help tools that are better, stronger, faster, much like TurboTax is better, stronger, faster than me just looking at the government website and trying to figure out how to fill out my taxes. That's really hard, much like the court system is really hard today. What if a GPT-like system were to go through trusted sources, like, by the way, Fastcase and DocAlarm have? We have 700 million judicial opinions and lawyer file documents that you could imagine, what if OpenAI had access to those 700 million legal documents to figure out even better how the law works? And then what if you set that free on access to justice initiatives to be able to say, I, as a pro se litigant that I'm clogging up the courts right now, maybe I can draft a pretty good brief based on real case law, based on real arguments that are statistically most likely to win for this judge, for this claim, or for this criminal matter. This starts to take it away from these are things that are going to eat my job as a lawyer, and they are instead maybe ways that we could be able to serve that 80% that haven't been served with a way that will not clog up the judicial system, because the judges will actually have good arguments rather than the pro se that we have today.
Well, Damien, I know we could probably continue this conversation, and we may have to have you come back in a little while and just kind of follow up on where we are, because it seems like we've just gone leaps and bounds just in the little bit that has been 2023. But I'm going to have you look into the future, so pull out your crystal ball, and over the next 2 to 5 years, where do you see tools like these large language models, whether it's Google BERT or OpenAI's resources or other products that I'm sure are right around the corner? How do you see that affecting the legal industry in the near term?
I would say that really these generative models, there are 3 ways to think about what they're doing, and those 3 ways to think about it are largely analogous to what lawyering has been in the past. And so I anticipate that way number 1 is where I, as a lawyer, say a bunch of stuff, but I don't provide a citation for that stuff. We'll call that a bullshitter, right? That's number 1. That's OpenAI today. They say a bunch of stuff. They're not giving citations for the stuff. So maybe you believe a bullshitter, maybe you don't believe a bullshitter, but you look at them warily, right? So that's option number 1. Option number 2 is, we'll call it a searcher. So this is somebody like a partner in a law firm says, I know there's law for this proposition. It's out there somewhere. Go ahead and find this law for the proposition. And so write the brief. And so you essentially write the proposition and you search really hard to try to find support for that, a citation that might be able to support that. So we'll call that a searcher, right? You could imagine a large language model doing that. So a large language model like GPT spits out a legal brief, but no citations. Now I have to be a searcher. So for each one of those sentences, try to find a statute that supports it, or try to find a case that supports it. We'll call that a searcher. That's option number 2. Option number 3 is a little more interesting, where we'll call it a researcher. That's where I, as a researcher, find the 5 or 7 cases that are really on point, and the statutes that are really on point. And then I extract from those cases the propositions that matter and the things that matter, and then I craft my brief around those cases and those statutes. That's not something that GPT can do, right? I mean, it kind of maybe can, but this is something that humans have done, and we'll call that a researcher. So for that, maybe that's the right way to go about it. Maybe that option 3, maybe we'll go with option 2 to be able to have it spew out things and try to call it on as BS or not, either prove or disprove the thing in option 2. Or option 3, Fastcase acquired a company called Judicata. Judicata assigned a unique identifier to every proposition. This thing is true. And also provided a unique identifier for every citation. That is every case, every statute. And so they created a product to say, hey, why did you, when you said this thing is true, why did you cite this case where your side lost? Why didn't you cite the 12 other cases that said this thing is true where your side won? So once you slap a unique identifier on the thing, you're getting close to the researcher. So maybe an AI-like result is to be able to say, I'm going to run a query for breach of contract in the Southern District of New York. And then maybe all the propositions that are statistically most common get bubbled up. So now you have your most common propositions. And then you as a somebody who is a researcher says, I like argument 1, no, not argument 2, but I like 3, 4, 5, not 6, but I'll pick 7. So I have a pick list of all my propositions, and then for each of those, I have a pick list of each citation, that is each statute that has that proposition, each case that has a proposition. That has provenance. That you know where it came from because you actually have hard cases. So between option 2, which is a searcher, which you're trying to deal, is it bullshit or is it not bullshit? Or option 3, you have ground truth from the get-go. To answer your question, crystal ball, I think that number 3 is probably going to win because it's the way that we do research today, and you don't have to deal with it whether it's BS or not BS.
Well said.
Yeah, I like that answer.
Well, Damien Riehl from Fast Case and with Sally as well. Like I said, we could continue this on forever. So, but we'll just have to bring you back on. But thank you very much for taking the time to talk with us.
Yes, thank you.
I'm so thrilled to be here. I listen to every episode, and I'm so happy you asked me. Thank you.
Awesome. And of course, thanks to all of you, our audience, for taking the time to listen to the Geek in Review podcast. If you enjoy the show, share it with a colleague. We'd love to hear from you, so reach out to us on social media. I can be found at GayBauerM on Twitter.
And I can be reached at Glambert on Twitter. Damien, what's your Twitter
Damien,
handle?
where can you be reached on Twitter?
Damien Riehl, first name, last name, DAMIENRIEHL. Or you can just search Damien Copyright, and I come right up.
Or if you guys are old school, you can always leave us a voicemail on the Geek and Review hotline at 713-487-7821. And as always, the music you hear is from Jerry David DeSica. Thank you so much, Jerry.
All right. Thanks, Marlene. And Damien, thank you very much.
Thank you all.
Thank you.
Bye.